Hello, my name's Luke Zadkovich. I'm a partner at the law firm Floyd Zadkovich, and we're putting on this arbitration series with zeiler.partners, the law firm in Vienna, Austria. Today I'm going to speak to you about commodity arbitration. Now this is a subset of arbitration, and in many ways it is like any other type of arbitration. It's based on an arbitration agreement in a commodity sales contract where you have a buyer and a seller who are buying and selling a commodity, and in that contract ordinarily they will agree on some type of dispute resolution mechanism. And today we're focusing on those commodity contracts that have a arbitration agreement in them. And in most instances, those arbitration agreements in commodity contracts will incorporate institutional rules. That is not always the case, and we do see on occasion arbitration agreements that are ad hoc, meaning that they do not incorporate institutional rules. But invariably, in the commodity arbitration context, you will see various institutional rules incorporated in an arbitration agreement. And that is often because the players in this market want to have rules that are agreed upon and put together by associations or collectives or other representative bodies of that particular industry. So we see in the grain industry, for example, GAFTA is an association there that has GAFTA arbitral rules. Similarly in phosphor, which is fats and oils, they also have their own rules. The LME for the London Metals Exchange, it also has a set of rules that govern arbitrations on the LME. And so these different types of institutional rules seek to deal with disputes that arise on those specific types of contracts. And each of them work much like any institutional rules. Sometimes they have structures and procedures in place that are more expeditious, depending on the level of the claim and how significant it is. They also often deal with quality and quantity issues that are quite specific to that type of commodity trade. But that said, you also have all of the other types of arbitral and arbitration law issues arise in commodity arbitrations as well, around the appointment of arbitrators, having a supervisory court overseeing the arbitration, which will be based on the procedural law, that is the law of the seat of the arbitration. And in some of these arbitral rules, they have levels of appeal, so you can actually appeal within another set of arbitrators that are part of the association. And depending again on the seat of the arbitration, you have perhaps rights to appeal to a court on a point of law, for example, in England, if that is not contracted out of by the parties. And so it's quite an interesting area. There's a lot to say about commodity arbitration. It is, as I say, a subset of international arbitration more generally, and parties that regularly trade on commodity contracts like to use these types of arbitration agreements because they are seen to cater for their industry. That said, we do also see many commodity contracts, typically the larger contracts and those that might be for multiple deliveries and shipments over a long period of time, incorporate the ICC rules and the LCIA rules, which is London Court of International Arbitration. Those rules have a more thorough, sophisticated process involved with them. The costs are often more expensive as well. But for those larger claims where you want a very robust procedure in place, much like a court would operate, at the outset, the parties will often agree on, as I say, ICC, LCIA, it could be AAA in the US, and others. You've got SIAC in Singapore, CIATAC in China, and the HKIAC in Hong Kong. There are others, including in the Middle East. That's a snapshot of commodity arbitration. I hope you found this interesting.